We're delighted to welcome you to the second of our two webinars in which we look at the top construction and adjudication cases of 2015. Our first webinar focused on the top 5 construction cases, and today we'll focus on the top 5 adjudication cases of 2015, highlighting the key facts and legal points of each case, identifying some specific lessons to be aware of for adjudicators and those using adjudication. Both of these webinars will be recorded and will be available on our Vimeo site. Details of how to access these will be given later on. Before we begin, there are a few housekeeping matters to start with. To minimise background noise, I've placed you all on mute, and if you'd like to ask any questions, please do so using the webinar chat function. In order to keep within 30 minutes, we'll be answering as many questions as we can at the end of the presentation rather than as we go along. So your speakers today, I'm Kate Gillis, a solicitor in the Construction and Special Projects team, specialising in construction and engineering dispute resolution and I'm based in Edinburgh. I'm joined by Lee MacDonald, a colleague in my team who also specialises in construction and engineering dispute resolution and is also in Edinburgh. Both Lee and I regularly advise on construction contract issues and disputes across a range of projects and clients.
Thanks, Kate. We will look today at the top 5 adjudication cases of last year, and for each we'll provide an analysis of key facts and legal points, whilst drawing out some lessons that can be learned, and which we hope can be considered and applied in your future adjudications. The cases we're going to be looking at today are, firstly, Aspect Contracts Asbestos Limited versus Higgins Contract plc, which is about prescription periods for enforcing or challenging adjudicator decisions. Secondly, the cases of Caledonian Modular, Higgins Investments and Harding versus Pace, which are cases relating to payment notice adjudications for interim and final payments. Next, we'll be looking at Stork Technical Services, RBG Limited versus Ross, which relates to adjudicators' fees. After that, we'll be looking at Broughton Brickwork Limited versus F. Parkinson, which is about the extent to which the adjudicator is responsible for examining the materials presenting to him or her and considers the onus is on the parties to clearly set out their arguments and draw important documents to the adjudicator's attention. The last cases we'll be looking at are the two of Rob Purton versus Kilker Projects and RMP Construction Services versus Shalford, which are decisions on oral contracts and show the court's reluctance to uphold jurisdictional challenges about the contractual basis for rights of adjudication, particularly where such a basis is probably obvious, i.e. when some construction works have been undertaken and paid for. Similar to the top 5 construction cases we considered in our last webinar, you'll see that some of our cases are from the English courts. Although England and Scotland have separate default schemes for adjudication, by and large the law and regulation of adjudication is common across both jurisdictions, and the English court naturally has a large number of disputes. Key lessons in the possible future approach of the Scottish courts can still be learned from such cases. So we will begin with Aspect Contracts Asbestos Limited versus Higgins Construction. This case was heard in the Supreme Court following the Court of Appeal overturning the first instance judge decision. After briefly setting out the facts and the judgment, we will consider the impact on prescription limitation periods and some practical steps parties to construction contracts should consider. This is against the background of a previous court decision in England that adjudication proceedings do not stop the running of statutory time bar periods for claims. So the facts of this are, Aspect was contracted by Higgins to carry out an asbestos survey. The survey was provided but failed to report on the full extent of asbestos present in the building Higgins were demolishing. Higgins incurred extra costs in removing the additional asbestos and 4 years later referred a claim to adjudication under the scheme, seeking £822,000 in damages plus interest. The adjudicator decided in Higgins' favour and Aspect paid £490,000 plus interest, being a total of approximately £658,000 to Higgins in line with the adjudicator's decision. Aspect then issued court proceedings 2.5 years after the adjudication decision, requesting the final determination of the disputes and repayment of the money paid to Higgins. The first instance judge rejected the claim, but this was overturned by the Court of Appeal. Higgins then took the appeal to the Supreme Court. The Supreme Court decided that if there is an implied right as a consequence of the scheme, that a party paying a sum found due in adjudication can seek recovery of any overpayment once there has been a final determination by a court. Also, in England, that paying party will have 6 years, which is the English limitation period, from the date of payment in which to raise proceedings for final determination. But the receiving party will only have 6 years from the original date of the cause of action to raise proceedings for final determination if they wish judicial confirmation of an adjudicator's award or are seeking an increase in the sum. Simply put, this means that parties will have different periods in which they can seek final determination of the matters that were subject to the adjudicator's decision. A winning party who is awarded a sum will only have the remainder of the original prescription or limitation period in which to seek final determination. By contrast, a losing party who is in turn to pay a sum to the other party will have their prescription or limitation period reset at the point of paying. So in the aspect case, even if the court's final determination of the dispute were to find Higgins to be due more than the £490,000 awarded at adjudication, because Higgins' right to claim additional sums had expired, no further sums would then be due from aspect. If, however, the court's final determination of the dispute were to find that Higgins was due less than the £490,000 they had paid, then Higgins would have to repay the difference to aspect. Aspect could therefore raise a challenge to seek the repayment without any risk of this resulting in them having to pay further sums. On the face of it, this creates something of an injustice, but in the court, Aspect noted that this was just a consequence of Higgins letting matters lie after the adjudication and not seeking either a judicial termination or Aspect's agreement to the adjudication outcome. The implications of this case need to be considered at the start of the process, i.e. when drafting the construction contract. Reliance on the scheme without any provisions in the contract could result in the above situation occurring. Parties should set out their dispute procedures clearly in their contracts at the start of a project, including an agreed approach to when adjudication decisions will become binding. After any adjudication decisions are made, parties should consider when the decision will become binding on either party. A winning party in particular will have to carefully consider whether court proceedings are necessary to protect the adjudication outcome. Alternatively, parties could agree to be bound by an adjudicator's decision to provide finality to both parties.
Thanks very much, Lee. Our next topic is actually a trio of cases. They all address the topical issue of payment notice adjudications for both interim and final payments. This year has seen the rise of the headline-grabbing smash and grab adjudication, but it's also seen an attempt by the courts to redress the balance, which, under the Construction Act, favours the contractor as payee. Let's start with the Caledonian Modular case, which was back in June 2015. The facts of this case are that the contractor's interim application was met by the employer's valid pay less notice. Negotiation then ensued, and the contractor reissued an updated version of its payment application to reflect the settlement discussions. The employer did not reissue an updated version of its pay less notice. The contractor subsequently claimed that the reissued documents actually constituted a fresh application for payment, and therefore the full amount claimed was due in the absence of an employer's pay less notice. The TCC rejected the contractor's submission that simply updating an application for payment meant it ought to be construed as a brand new application and therefore require a pay less notice to be issued in response. In this case, much turned on the fact that the documents were not clearly labelled as being an interim payment application. The contractor was therefore unable to rely on its retrospective argument that the documents were intended to be such an application for payment. Mr. Justice Coulson commented that if contractors want to have the benefit of amended provisions, then they should be obliged to set out their interim payment application claims to the employer with proper clarity. The next case in this theme was just 2 months later, in August 2015, Henny Investments and Harding against Pace. In this case, Mr. Justice Aikenhead commented that the document relied upon as an interim application must be in substance, form and intent an interim application and must be free from ambiguity. He followed the approach that if there are to be potentially serious consequences flowing from a document being an interim application, it must be clear that this is what the document purports to be, so that the parties know what to do about it and when. Finally, at the tail end of last year, in December 2015, the court confirmed in Harding against Pace that the failure to issue a pay less notice against a final application for payment does not preclude an employer from adjudicating on the true value of the final payment in a subsequent adjudication. This contrasts with the position for interim applications for payment. That position remains as determined in ISG against Stevenage in December 2014 and also Galliford Try Building against Estura in February 2015. In both of these cases, the court found that an employer could not raise a separate adjudication to challenge the amount payable on the merits if its failure to issue a payment notice or pay less notice had resulted in the interim application becoming due in full. Instead, the employer had to await the next interim application and make an adjusted payment at that stage. So where does that leave us? Despite the cases of Caledonian Modular and Henia having redressed the balance somewhat, contractors or subcontractors as payees remain in the more favourable position. This position is that, provided payment applications are validly made and on time, they will become due in full in the absence of the correct employer notices being issued in response. Whilst this might seem unfair, it is important to remember that this position has been arrived at by legislators in response to the widespread payment set-off abuse that was practiced by employers in the 80s and 90s, which led to contractor cash flow problems. Also, the potential unfairness of a windfall accruing to the contractor based on an inflated payment application can be avoided by the correct employer notices being validly given and on time. Employers and their representatives should therefore diligently adhere to the payment notice requirements.
Our next case is one which our own Ian Drummond was solicitor advocate for at the beginning of last year. The facts of this case are complex, which is the case of Stork Technical Services Limited versus Ross, but I shall try and briefly summarise for the purposes of this webinar. The pursuer was the employer under a contract for the construction of a factory production line. A series of disputes arose between Stork and the contractor, SGL, two of which proceeded to adjudication. In the second adjudication, Mr. George Ross was nominated to act as the adjudicator. The adjudication lasted for over 6 months. In a 228-page decision, Mr. Ross decided that the Stork required to pay just over £1 million to SGL. Stork refused to pay on the grounds that Mr. Ross had failed to comply with the rules of natural justice and also had not exhausted his jurisdiction. SGL subsequently raised enforcement proceedings which were unsuccessful. Consequently, Mr. Ross's decision was held to be unenforceable and was set aside. Stork had paid over £140,000 in respect of Mr. Ross's fees, VAT and outlays for the adjudication. Those payments had been made to Mr. Ross's then employer, who had issued VAT invoices in respect of Mr. Ross's services. Stork sought to recover the money it had paid on the basis of the law of unjustified enrichment. It argued that his contract was with Mr. Ross. The payments had been made to Mr. Ross's employer on Mr. Ross's behalf, and that it was Mr. Ross and not his employer that had received a benefit. Stork went on to argue that the money was repayable because there were no legal justifications for Mr. Ross retaining the payment once his decisions had been set aside. Tragically, Mr. Ross died before the case was concluded, and the action was then directed against his wife as his executor. In his decision in the commercial court at the court session, Lord Tyre decided that he was required to answer 2 key questions for this case. Firstly, who were the correct contracting parties? Secondly, was Stork entitled to recover the fee paid by it on the basis of the law of unjustified enrichment? The case was ultimately decided on the basis of the answer to the first question. The court held that, as a matter of fact, the contract had been between the parties to the adjudication and Mr. Ross's then employer. Lord Tyre found that whilst nomination of the adjudicator by the ICE was personal and the agreement signed by the parties named Mr. Ross as the contracting party, the agreement was for the supply of Mr. Ross's services as an adjudicator. Mr. Ross had made it clear in the accompanying correspondence that he was entering the adjudication agreement on behalf of his employer and that his employer would invoice the services to be provided by Mr. Ross. Lord Tyre also considered that Mr. Ross's employment, payment and VAT arrangements provided further evidence that the contract was with his employer and not with him as an individual. Lord Tyre then went on to make a number of non-binding comments referred to as obiter, which are of a more general application in relation to, firstly, the remedy of restitution under Scots law, secondly, an adjudicator's right to interim payments, and thirdly, the ability of an adjudicator to limit his liability in respect of repayment of his fees. Kate will briefly discuss points 2 and 3.
Thanks, Lee. So firstly, in relation to interim payments, the adjudicator's agreement required the adjudicator to keep parties appraised of his fees and to submit interim fee bills. The defender submitted that this demonstrated that the interim payments were for services rendered prior to the issue of his decision. Therefore, the fact that the adjudicator's decision was held to be unenforceable did not affect the adjudicator's right to payment of these interim fees. Lord Tyre, however, disagreed. He followed the analysis in the previous case of PC Harrington against Vistec International, in which it was decided that interim payments were actually an advance payment in anticipation of the adjudicator's performance. The fact that the contract allowed the adjudicator to issue fees on an interim basis did not alter that position. The adjudicator was entitled to be paid for delivering a decision, not for undertaking the work necessary to provide that decision. In relation to point 3 about the limitation of liability, Clause 10 of the adjudicator's agreement was a limitation of liability clause stating the adjudicator is not liable for anything done or omitted in the discharge or purported discharge of his functions as adjudicator unless the act or omission is in bad faith. The defender argued that Clause 10 was sufficiently wide to cover a claim for repayment of the adjudicator's fees, which included third-party disbursements. Therefore, the defender submitted, even if Stork was entitled to be paid the monies claimed by it, Clause 10 was a complete answer to that claim. Again, Lord Tyre disagreed. In his view, Clause 10 did not preclude or limit a claim for repayment by the pursuer based on breach of contract. Rather, the clause's application was limited to losses sustained or liabilities incurred to a third party through the act or omission of Mr. Ross. Lord Tyre decided it had no relevance to a claim for repayment of fees. So where does that leave us? The courts undertook a careful review of the terms of the contract between the parties and determined the rights and liabilities of both parties following that review. This demonstrates the importance of the terms of the bargain reached between the parties. In Lord Tyre's opinion, the service for which the adjudicator was being paid was for the adjudication of the parties' dispute. Therefore, if an adjudicator wishes to be paid for the work he does, regardless of whether he produces an enforceable opinion or not, he needs to state this expressly in his agreement with the parties. Otherwise, his right to payment will fall with his decision. Finally, a claim for repayment of the adjudicator's fees will not be defeated by a general limitation of liability clause. A claim in that situation is not a claim for damages, it is a claim for restitution. And a standard limitation of liability clause will only protect the adjudicator against a claim for losses incurred as a consequence of the adjudicator's acts or omissions. If he wishes to avoid having to repay his fee, he must spell this out in the contract with the parties.
Thank you, Kate. Our next case is Broughton Brickwork Limited versus F. Parkinson, which demonstrates the court's reluctance to interfere with the merits of an adjudicator's decision and underlines that clear presentation of a case at adjudication is important. Broughton Brickwork were employed by F. Parkinson as a subcontractor on a building project. The terms of the contract provided for adjudication under the scheme. The contract also specified service methods and timescales for payment and pay less notices. An interim payment application was made by Broughton Brickwork, but this was not paid, so they raised adjudication proceedings against F. Parkinson. The adjudicator was asked by F. Parkinson to consider subsequent payment cycles, which included payment notices and pay less notices that addressed the payment issue in dispute. However, the adjudicator found that these subsequent payment notice and pay less notices had not been served in accordance with the contract requirements. This was because he assumed that their service was by post, and because of the dates of the notice served late. He therefore found in favour of Broughton Brickwork. F. Parkinson considered that the crucial pay less notice had been served timiously, as it had been served by email, which was a valid method of service. The email was contained in the adjudication productions, and therefore evidenced the valid service. However, the adjudicator had not seen or considered that email. After issuing his decision, the adjudicator admitted in correspondence that if he had seen and considered the email, he would not have found in favour of Broughton Brickwork. But the reality was that the adjudicator had not seen or considered the email, and the court was asked to decide whether his decision should be enforced.
The judge restated the court's preference for enforcing adjudication decisions, even ones which contain errors, and he noted that an adjudicator is entitled to make mistakes, whether in fact or law, even ones which are obvious and fundamental, without thereby rendering his decision unenforceable, so long as he acted within his jurisdiction. The judge also noted the grounds when a court will not enforce a decision, and this is when a decision is reached in serious and material breach of natural justice. He restated the court's approach that adjudication is a rough and ready process which is fallible, but this reason in itself is not sufficient to render a decision unenforceable. The court did not consider that the adjudicator had a duty or responsibility to look at and consider every piece of information presented to him. Rather, it is the duty of the parties to set out their case clearly, through the written submissions and any oral hearings, and to draw the adjudicator's attention to any pieces of information which are particularly crucial. F. Parkinson's adjudication submission in this case and productions contained numerous errors. The submission documents did not clearly make the point that the crucial pay less notice had been validly served by email. They also did not specifically draw attention to the email which evidenced the valid service of the crucial pay less notice. Further, the production references in the submission contained page numbering errors, meaning that the adjudicator was not directed to the production that contained the crucial email evidence. The court was particularly critical of these errors. F. Parkinson's defence relied heavily on the valid service of the crucial pay less notice, indeed the entire case turned on it, evidenced through the email concerned. So the judge was clear that it was for them to draw it to the attention of the adjudicator, not for the adjudicator to look for and find it. The court found that the factors which caused the adjudicator to overlook the crucial evidence were the errors and the weak presentation by the claimant. As it was the claimant who was relying on that crucial point, they had the responsibility to ensure it was adequately brought to the attention of the adjudicator. They had not done so, and so the adjudicator had overlooked it. The court therefore did not even consider this to be an adjudicator mistake, but rather an omission caused entirely by F. Parkinson's poor submissions. This case highlights that the responsibility for presenting a case and drawing all material facts, circumstances and evidence to the adjudicator's attention rests with the parties. An adjudicator would be expected to consider all points made in submissions and to review all evidence that he is directed to, but not to have to seek out evidence. A clear submission is essential to set out your arguments, and good presentation is also important, including accurate and clear referencing and indexing of productions. Whilst these things seem obvious, in the short timescales of adjudication, the basics can sometimes be overlooked. It is therefore important not to sacrifice the quality of your submission in favour of speed and/or the quantity of productions. As a referring party, it is worth taking the time to create and present a well thought through and ordered case.
Our final cases today are that of Purton, trading as Richwood Interiors versus Kiltker Projects Limited, and RMP Construction Services versus Chalford. The first case, Purton versus Kiltker, is an English judgment of the TCC regarding the enforcement of the adjudicator's decision where there was no written contract in place. It is worth noting that this is the first reported case considering oral contracts since the repeal of Section 107 of the Construction Act in 2001. Under the old legislation, a dispute could not be referred to adjudication if the contract was not in writing. The decision in Purton's case, therefore, provides a useful guidance on how the adjudication can be approached when dealing with oral contracts. The facts of the case are that Mr. Purton undertook joinery works for Kiltker Projects at a hotel. He claimed that he entered into an oral agreement where the scope of works was originally valued at approximately £350,000, but it subsequently varied in value, quantity and quality. The works were carried out by Purton, and some payments were made by Kiltker. However, when Purton submitted a final account requesting further payments, Kiltker did not pay and also did not issue any pay less notice. Purton referred the dispute to adjudication in accordance with the scheme. Kiltker disputed that there had ever been a contract and argued that the adjudicator therefore did not have jurisdiction to determine the dispute. The adjudicator did not agree with Kiltker's arguments and awarded Mr Purton the payment of an additional sum of £147,233 plus legal costs. Kilker refused to pay. As a result, Mr Purton sought to enforce the adjudicator's decision. Again at court, Kilker argued that there was no contract, or, alternatively, that the dispute arose under a different contract which had different terms from the one which formed the basis of the adjudicator's decision. In relation to the first point, the court held that it was beyond argument that there was a contract. There was substantial performance on both sides, with Mr Purton doing the works and Kilker making payments of approximately £654,000. The court also noted that to suggest that what had happened was merely a series of ad hoc works, quote, stretched the imagination unreasonably, unquote. In relation to the second argument presented by Kilker, the court distinguished two scenarios. Firstly, that the contract had been relied upon was incorrectly identified on one or more points. The court considered this and held that the jurisdiction to refer a contract to adjudication was dependent upon the existence of a construction contract and a dispute arising under it, and it is not dependent upon identifying each and every term with complete accuracy. The second scenario was in relation to the situation where the contract relied upon never actually existed, or the dispute did not arise under it. The court concluded that, at least in a case where there can be no doubt that the adjudicator, if properly informed, should and would have concluded that he had jurisdiction and the proper basis of a jurisdiction, it does not make a difference then to the outcome of the adjudication. In other words, the reliance upon a different contract should not affect the substantive outcome of the adjudication.
This case provides an important lesson that although the formation of an oral contract may seem an easier option for the parties, that written contracts are more beneficial in the long term. The parties should also take time to consider the effect of their correspondence and be able to support any potential claims by reference to sufficient evidence. The judgment is also useful guidance that not every term of the contract must be identified before referring the case to adjudication. This reiterates that the purpose of adjudication is to provide quick and effective dispute resolution, and therefore substantial performance on both sides may well be sufficient to form the basis for the adjudicator's jurisdiction. Moving on now to the very recent case of RMP Construction Services against Chalcroft, there are several parallels with the case of Perkin against Kilker. In the RMP case, the parties disagreed on the documents that formed the basis of their contract. This was important because it impacted on when a pay less notice had to be served, and more specifically, whether Chalcroft's pay less notice, dated 26 August 2015, was served in time. The documents in question included an email accepting the work, 2 different letters of intent, and a subcontract order. RMP argued the case for the earliest document, which was the email sent, whereas Chalcroft advanced the other 3 options in the alternative. If RMP was right, the payment provisions of the scheme applied and Chalcroft's pay less notice would be late. If Chalcroft was correct, it contended that the JCT payment provisions were incorporated, and it was at least arguable that the pay less notice was served in sufficient time. At adjudication, the adjudicator accepted RMP's argument that the email formed the contract and ordered that Chalcroft was to pay £260,000. Chalcroft refused to pay, and RMP took the case to court. The judge considered at length the different contractual routes Chalcroft argued for. He concluded that it was reasonably arguable that either the letter of intent or the subcontract could be the contract. However, the judge concluded that as each of the alternative contract routes was sufficient to found the adjudicator's jurisdiction under the scheme, to rule RMP out of court simply because it had misidentified the contractual provision that gave the adjudicator jurisdiction would be to once again return to the formalistic obstacle course against which I protested at paragraph 23 of Purton. The judge therefore concluded that the adjudicator did have jurisdiction. He recognised that there would be possible differences in the outcome depending on which contractual route applied, but characterised these differences as going not to jurisdiction, but rather to the substantive outcome.
Together, these cases then will therefore be welcomed by referring parties seeking payment, but possibly not by responding parties trying to avoid payment due to a lack of payment or pay less notice, who may see it as unduly allowing adjudicators to make mistakes for which responding parties have to pay.
We have now come to the end of our presentation. We hope it's been useful and interesting. We're actually just at the end of the time allowed, so if you do have any questions, please feel free to contact us after the webinar. I'll just take the few remaining seconds that we have to remind you that both of the webinars in this series will be recorded and will be available on our Vimeo site. So do please share the link with any colleagues who might find the webinar useful. We'll be circulating details of the recording to participants after the webinar. We would also welcome any feedback that you have on the format and the content of the webinars so that we can improve them. And we are particularly happy to hear your thoughts on topics which you might like to see covered by future webinars. So thank you very much for listening, and we look forward to welcoming you to future webinars.
Thank you.